Hi, I'm attorney Greg Dell, and today I'm here with attorney Rachel Alters. How are you, Rachel?
I'm good. How are you?
Good. And today we are going to discuss a common issue that unfortunately we see a lot of times for claimants that contact us, and that deals with the importance of getting every single thing possible to support your disability claim into the administrative record. So first, Rachel, what is the administrative record and when does it close so that people understand what that is?
Greg, the administrative record is basically all the medical records, testing, notes from the insurance company, everything that's been done on your claim to work up your claim. And that closes as soon as the final decision is made by the insurance company. So once they determine that they're going to terminate your benefits, you have no more appeals available, that closes and nothing else can be added.
Okay. And the administrative record is building from the moment someone submits a claim until the period of time when they finalize an appeal.
Exactly.
Okay. So I want you to discuss, I know you and I were discussing before we got on tape about a recent case that came out where somebody tried to submit additional information after the appeal period and what the court did with that.
Yeah, there is a case, it was against Aetna, and the plaintiff was upset with Aetna because at the time of the decision of the claim, when Aetna decided to terminate the benefits and give no more appeals, the plaintiff had not had a diagnosis yet of the disabling condition. The doctor was still trying to figure out what was going on. So unfortunately, the claim closed, the administrative record was closed, and once they got that diagnosis, which was, a hernia or chronic abdominal pain, that couldn't be added into the record. So the judge never got to look at it. The judge never got to see that the diagnosis was made.
And sometimes people think, well, Aetna's going to try to do the right thing. I got this new medical information. It's a no-brainer. This is why I'm having my chronic abdominal pain. Will you look at it and now reinstate my benefits because now my doctors have conclusively told me what's wrong? But Aetna said no, and they can do that?
Correct. Absolutely. And the plaintiff went to the judge and said, but this isn't fair. Why is it fair that just because my time limit ran out under the ERISA statute that I can't submit my medical condition to Aetna? And the judge said, I'm sorry, this is how it is, and ERISA governs whether or not anything additional can be added, and they're not going to change that federal law, unfortunately.
So as you know, most appeals, you have 180 days on a long-term disability appeal to submit your appeal, and sometimes claimants say to us, well, why do you have to take so long? Or I want to get it done in 30 days. And this is a perfect example of why it's so important to get every single thing in on time, because if you don't, it's never coming back in. And I always use this example to say, God forbid you submit your appeal, they deny it, and you get hit by a truck the next day and you're paralyzed.
Right.
Obviously you couldn't work.
No.
The court wouldn't have to consider that information. That's how hard and fast this rule is.
Right.
So if your claim's been denied, or you're currently on claim concerned about being denied, or you have to file a lawsuit for a disability appeal, feel free to give any of our attorneys a call. We'll always offer you a free consultation, and we look forward to the opportunity to work with you.
Thank you.